Vanakkam, everybody. The distinguished dignitaries who are going to participate in various sessions during this ThinkEDU, the organizers, and the pillar of strength behind this organization, the New Indian Express Group. Congratulations to every one of them. My time has started ticking. As they say, the very basic purpose of any education or any educational system is to enhance the ability, capacity of individuals, to make them ready for further challenges in life, to empower them, to uplift them. What we normally call asatoma sadgamaya, tamasoma jyotirgamaya. So therefore this transition or travel from darkness to the enlightenment. Study of law is no different. I have spent something like 40 years in the field of law. First 32 years as a lawyer, last 8 years as a judge. I can claim some experience when I say and make certain comments on this issue. When I studied law, the LLB course was the most rudimentary course. It was normally taken as a default arrangement wherever any student did not get any admission in any prestigious institution or course, he would land up in a law college. Today the things have changed. Today law is no longer a default arrangement, but it's a choice of many students. We have something like more than 25 national law schools in the country. It started with the revolution, which was National Law School, Bangalore. And it is now getting to be the first choice of many students, generations of students. In my days, my college used to begin at 7, end at 10 in the morning. Then thereafter, we would land up in courts just to watch the proceedings in various matters, and our education began after 10 o'clock. So the theory part was something touched upon during courses, but the practical application of whatever we studied was in our innings through the courts. Today the courses have gone radical changes. There are hands-on approaches. There are emphases on moot courts, competitions. Almost the lawyers are ready to take on the challenge after they graduate from the law courses. But even then, there are certain defects or deficiencies. A medical professional, after he secures a degree, is ready to take up challenges in the world. He can set up his dispensary. He doesn't need any further education. Similarly, an architect or an engineer. But a law professional, whatever he may have studied in law colleges, is just the tip of the iceberg. So his journey actually begins after he joins the law course, after he joins the profession. One more difference, and that's perhaps we as a society, we must make some ideological corrections or course correction in our approaches. See, a medical or dental professional is expected to do some internship as a part of curriculum. I don't know why, but no other professional course in this country contemplates any kind of internship in which the students are supposed to give it back to the society whatever they have learned. We expect medical professionals to do free services in rural sectors, give it back to the society, but not the other professionals, chartered accountants, or engineers, architects, or even lawyers. Why is it so? Is it that your profession is actually premised on the idea that perhaps whatever you have learned, you must give it back to the society? But so is the medical profession. Both professionals coming from these two streams call themselves to be belonging to noble professions. Law as a profession is something which is spoken of in Part 3 of the Constitution. The moment a person is arrested, he must be brought before a magistrate within 24 hours, and he must be provided the services of a legal professional of his choice. So that's the elevated status which has been given to law as a profession. Why do we say so? Our Supreme Court's emblem is yato dharmas tato jayaha. Whatever is right shall prevail. If whatever is right shall prevail in the society, human relationship is such that with the advances in technology, with the multifold channels which are opening up, there are many areas of friction amongst the members of the society. For an orderly society, what we go by is the basic norm, which is rule of law, that the society be governed by legal principles. Who best can advocate, can give counsel to the society than the lawyers as to what are the principles, and in case there be any friction or there be any violation, who as a professional can take care of such situations except the lawyers? I had very interesting experience when I was chairperson of NALSA. NALSA is National Legal Services Authority. What we found is, and this is I am saying only so far as criminal matters are concerned. Why confined to criminal matters? Because legal aid is most required in criminal matters rather than civil. In civil matters, you have reaction time. In case a suit is filed, the defendant can think about what strategy to be employed, who should be contacted as a counsel. Whereas in criminal matters, the moment he is arrested, the reaction time is very, very less. Within that shortest possible time, he has to avail of certain legal remedies. If we go by the statistics, I don't know exactly how much percentage today, how much of population is below poverty line, but let us take a normative figure of 66%. If 2/3 of our population is below poverty line, then logically, 2/3 of the matters on criminal side must be in the hands of legal aid services. But they are not. They're not more than 15%. What does that mean? The gap between 15 and 66, which is almost half the population, though it is completely beyond their means, end up paying huge fees by way of legal remuneration to legally trained professionals, or go beyond their capacity. They may sell their jewelry, mortgage their properties in order to take care of litigations which are impending and which are like swords on their heads. What does that mean? Number one, either people are not even aware that there is an apparatus like legal aid, or they don't have confidence in the legal aid machinery or the apparatus. I, as a chairman, I thought that two areas. Number one, we must have awareness. So therefore, we launched what is called 42-day campaign, in which we wanted to cover every village in the country at least thrice. And we covered every village, 19.5 lakh villages we covered during this period of 42 days. The awareness, the flame of outreach definitely reached every nook and corner of the country. As a result of which, some of the collateral kind of advantages. One, our disposal, highest disposal before that in Lok Adalats used to be 14 lakhs per day, which is after every 3 months. The last Lok Adalat figures when I demitted office as legal aid chairperson was crore and 6 lakhs. Why? Because of this approach, because of this knowledge. And that's where perhaps I think we as legally trained professionals are lacking. Number one, the father of legal aid movement in the country was Krishna Iyer, because he was the first chairperson of the committee which drafted something on legal aid way back in 1971 when Justice Krishna Iyer was judge of the Kerala High Court. And what he said is that it is unfortunate that people in this country are not even aware of what their rights are not eligible, not even sort of availing the services of legally trained professionals. How many times have we seen that so many people, they mortgage their properties in ignorance and they end up being exorbitant rates of interest, which may not be consistent with the legal principles. Something like Do Bigha Zameen or Mother India. These are the normal examples which are there across the length and breadth of the country. So what do we now have to have a change in approach? I suggested as chairperson of NALSA, number one, that study of law should not be confined only to classroom study, but as a part of the curriculum, the students must, every college must adopt at least 2 villages in the surrounding areas in the 4th and 5th year of the law course. Every student must be made to go reach the rural population, have an interaction with that rural population. I'll give you one example. We have legislations like Domestic Violence Act. How many complaints actually come from rural sector? Is it that there is no domestic violence in the rural population? No, because those women do not have that kind of confidence to approach the concerned authorities. If you have a regular interaction with those ladies, with that entire population, I just gave an example of those ladies on domestic violence front. There could be a number of such cases, like those who are entitled to certain concessions as being members of, say, certain communities. It is this awareness, apart from the awareness, the regular interaction with that cross-section of the population which lives in rural sector. It will then make study of law more on the substance side rather than just getting a degree. What do we find today? The students are, of course, they get the degree, and then thereafter there is an avalanche, either to come to cities or to bigger courts, wherever there are opportunities come in plenty, or there are the regular stream, which is the corporate world. How many of us actually go to the rural sector as lawyers? Very few. So one part which study of law, if you really want the study to be responsible on the social front, then according to me, the major emphasis in the entire approach must be that there must be 1 year of compulsory internship where students must be requested to work in rural population. This example or instances like this will make them completely aware of the problems, the kind of lifestyle, the kind of infirmities which that population has. It will make them, it will turn them into good human beings, complete professionals, which will then aid the very same professionals to be one of the first-rate professionals in the entire country. Second part, and that according to me is something which we are missing. We see in defense forces, Army, Navy, Air Force, even right up to the rank of lieutenant generals, people keep on doing courses every now and then, almost every 6 months or 1 year. You'll hear that I had gone to so-and-so course, I had gone to so-and-so course. It doesn't happen in legal profession. I had one very beautiful experience. I keep going to National Judicial Academy, Bhopal as a resource person. And once there was a contingent coming from Sri Lanka, some of the judicial officers who were to be given training at Bhopal, National Judicial Academy. And the persons concerned who were to be trained were of the level of what is called Civil Judge Junior Division Magistrates. That's the lowest of the levels in the judicial hierarchy. Very well, there were about 20 odd such participants. Apart from that, there were 5 district judges, 2 judges of the High Court, and 1 judge of the Supreme Court of Sri Lanka. I asked that judge of the Supreme Court, see, the course is meant typically for the magistrates. Why are you here? And she said that it's always better to keep sharpening our knowledge. It's always better to keep revisiting the same ideas. So why should education be confined to the lowest of the ranks? And that was something like an eye-opener. So I said, what she says is absolutely right. Perhaps I think we should also have something for our ranks. Of course, there are courses at National Judicial Academy, even for the judges of the High Court, but they are normally for judges between 0 to 5 years, not beyond that. At levels beyond that, there is no course or there is no sort of, refresher ideas which are gaining ground. So therefore, according to me, study of law, today we have come a long way since I was member of Law College. Today the children, today the students are definitely having more opportunities, more windows of learning, and more hands-on approach. No doubt about it. If I was at 0 level, perhaps these students are definitely at 6 or 7 level. But there are 3 more levels yet to be crossed. And those levels will be crossed if you make study of law not just confined to universities and colleges, but to the masses, to the societal apparatus. It is then that study of law will be what you normally say complete. Our freedom struggle shows that most of the lawyers were the social engineers, not just on the freedom struggle, but various other social problems where it sought to be tackled by them. So if you make study of law more vibrant, then perhaps there will be definite change in the profile of the society. Thank you so much.
So much, Mr. Lalit. You talked about the internship, and I think that was a really significant suggestion. Why restrict it to just rural areas? Because I find that we perhaps have the best laws in theory, but in practice we fall very short in terms of both awareness as well as in practice. So why not make this a compulsory part of legal education everywhere?
You are right, it should not be confined to rural sectors. I just gave an example. Why? Because in rural sectors, the opportunities are lesser and lesser. So therefore, the exposure of that rural population to something what you could normally call processes of court, study of law, or being aware of legal principles is definitely lesser. It's not as if that there are no poor in urban areas. It can certainly be extended everywhere. I just put emphasis on the rural sector. That's just about all.
Coming back to the idea that we perhaps have the best laws in theory, especially when it comes to women, I think we have some of the most progressive laws. But when it comes to the actual practice, we fall very, very short. Would you agree with that?
Yes, you are right. There was a proposal which was mooted by, and the matter is still under consideration. The proposal was mooted by Ministry of Child and Women Development. And according to them, there must be what is called an officer to be deployed at every district, and maybe at a future level, at every tehsil level, so that the population in the surrounding areas feel confident that there is somebody, a nodal officer, who can be approached in case of any doubts, in case of any kind of emergent situations. So such a proposal is something which is of great dimension and significance. I'll just tell you, we have now advocated that on the same lines as public prosecutor's office in every district, let there be legal aid defense counsel office in every district. There are about 780 odd districts in the country. We have started with 350 districts, so almost half of that. There will be a regular legal aid defense counsel system, one chief counsel to be assisted by 3 or 4 assistant counsels. So my proposal to ministry was that one of them could be a lady advocate who can be a nodal officer in case any female population living in that particular district wishes to come. And there is an element of confidence when you come out with certain kind of harassment or maybe areas. And that's the reason why such an arrangement will be more conducive. So it will serve not only the purposes of legal aid, but at the same time, some of the social ideas which are advocated by legislation such as Domestic Violence Act.
That's true. You know, for instance, you have the Anganwadi workers who, have made such enormous strides in education and health at the village level. Can we not have something similar in terms of a legal aid officer at the village level?
Of course, yes. There are, as of now, there are what is called paralegal volunteers.
Yeah.
And some of these Asha Anganwadi workers are part of the regular, the stream who work as paralegal volunteers. Some of the law students, some of the retired civil servants, they also share that responsibility. But as a regular kind of machinery, it is better to have machinery with some status. And if this works, then perhaps I think there will be one nodal officer in every district who can take care of any such complaints. Asha workers and Anganwadi workers, of course, have certain other areas of operation.
Yes.
Their duties are slightly different,
Yeah.
Anganwadi. But on the legal front, if there is a dedicated officer who can always be available, that should serve the purpose.
So, when you began in the profession, things were, of course, very different. India was a different country. 37 years in the Supreme Court. Why did you choose to become a judge rather than remain a lawyer? Far more lucrative it would have been, I guess. So, you know,
These
maybe for
these are
young law students, what prompted you to choose becoming a judge?
See, of course, yes, money is definitely required for every human individual to survive, to thrive in the society. But after a point, that loses significance in life. As they rightly say, if you have a good son, why do you require dhan sanchay? Correct? If you have a bad son, then again, why do you require dhan sanchay? Because he is going to fritter away everything. Correct?
Daughter as well.
Yes, yes, anybody. What I mean to say is this. So, ultimately, after a point, that loses significance. So, therefore, then you need something which gives you satisfaction, which gives you, at the end of the day, you feel satisfied that yes, I did something. That's how I accepted. Today, my third innings has begun where I am now visiting professor in some of the law colleges.
I believe
So
also
therefore,
Sastra, you delivered a lecture.
Sastra, yes, delivering one lecture is not. I am now regularly visiting professor in 2 or 3 institutions. So therefore, that's what I intend to give back to the society.
But one hears of the Supreme Court only when there is a controversy. There is a controversial judgment or there's a controversial case. The collegium, of course, is something that I have to ask you about. We cannot have a conversation about law these days without asking about the collegium. You know, you spent, 74 days
Yes,
as Chief Justice. Did you ever feel the pulls and pressures of the executive on you?
Time is only 3 minutes now.
Enough for you to answer this question.
Okay.
Do you get midnight calls saying, you know,
Not at
perhaps
all.
this judgment could
Not
be
at
this
all.
way?
Not at all. Not at all. See, as Chief Justice, you are, apart from being a judge, the additional mantle that you put on is being the administrative head of what is called the listing. The listing is one part. Determining the composition of benches is one part. And what kind of benches should we have is also another.
Should they
I'll tell you,
reflect
that's right.
diversity,
Yes, that's right.
inclusiveness?
Never in the history of Supreme Court, more than 2 constitution benches had ever sat together. In my tenure of 74 days, I simply went by the mathematical calculation. We were 30 judges to begin with. I divided 30 by 5 and said that there are possible 6 constitution bench combinations. And in my time, all 6 benches were constituted. And at a time, on a particular day, 3 constitutions benches were sitting together simultaneously. So therefore, that's one function which the Chief Justice is definitely having the prerogative. According to him, he may constitute benches, list the matters, so therefore that's his prerogative. The second prerogative on the administrative side is, of course, the collegium meetings.
Yeah.
So he is the one who calls a meeting, makes a proposal as to who shall be the judges, etc. On neither of these 2 fronts, I have had any kind of, either instructions or even remote or even indirect suggestions coming from the executive at any juncture.
Do you have any regrets?
On what front?
On things that you had set out to achieve?
Not at all. No regrets
because
at all.
you had listed 3 priorities when you had taken over.
I had said that, number one, because there were many matters which were lying without getting listed. See, what happens is, especially during COVID times, we had, our disposal had taken a back seat. We were more into sort of, making ourselves available through virtual mode.
Yeah.
What happens in virtual mode is that a matter which is capable of being disposed of in 3 minutes may take 10 minutes. Because there are communication defects, there are communication gaps. So our disposal, which was 60 matters a day on Mondays and Fridays, which are miscellaneous days, had come down to almost 30, 35. That left tremendous gap between the filing of the matters and the disposal. So we were on the negative side so far as disposal is concerned. So one priority which I said was listing of all matters,
Yeah.
disposal to be more than the list filing,
And also transparency.
transparency, and that is why more and more constitution benches. And not just constitution benches, like one typical example is the death sentence matters where somebody has been awarded death sentence and the appeals are pending in Supreme Court come before a bench of 3 judges. The normal practice in Supreme Court is to have 1, or at best 2, or at best 3 judges of combinations of 3. With the result, all these death sentence matters must get listed only before such combinations. And it becomes somewhat, the judges also are human beings. So after a while, they entertain feeling of fatigue. That how many death sentence matters am I supposed to deal with, correct? So that's how when I constituted 6 constitution bench combinations, I said constitution bench requires 3 plus 2. So those 3 judges combination will have all matters including death sentence matters. So therefore, I doubled up the benches. With the result, many death sentence matters were also listed, disposed of. And it is a part of constitutional jurisprudence now that death sentence matters, if there be delay, then that may afford a ground for the person concerned to have the death sentence commuted to imprisonment for life. So our procedural delay should not afford any kind of ground, and the sooner we dispose of the matters, one way or the other, whether you affirm or you don't affirm, but the matters must be disposed of. That's how.
As we can see, time's up, we're told. There's so much else that we needed to talk about, but perhaps some, yes. Of course. It's your prerogative.
You are the organizer, sir. My time is up. Yes, sir.
Is there any change which
if you permit, I'll take about 10 minutes to explain this.
No. You can't.
No, this is not something which can be, if you just ask me one single sentence, is there a need to change? No. Okay. Now, if you want the reasons, give me 10 minutes.
Spoken like a true lawyer. All the law students at the back, this is how you have to function. Thank you so much for being such a sport.
One hand which is getting raised in that corner.
If you promise to ask the question in half a second, he'll promise to answer in 1 second. Yeah, quickly.
Hi, this is Jweria. I'm a journalist with edX. So recently, NLU Delhi hiked their fee. It was a massive hike percentage, almost 80% hike. The students said that this will push them towards corporate law. They'll take loans, etc., to pay off their fees. Do you believe that public institutions of law should be protected from such hikes in fee that we are seeing in a lot of public institutions in other fields
I think
as well?
we've got. Thank you.
I used to be part of the governing council of National Law School, Bangalore, and this is a typical question which always the administration is sort of called upon to decide. There are so many trained professionals whose services are engaged as professors. Naturally, very handsome amounts are paid to those professors. So as compared to my days when there used to be just about few professors and my learning was actually in the court of law, today the colleges function right from 8 o'clock till almost about 7 o'clock in the night. So therefore that's the law course, people are engaged and they are paid very handsome fees. So therefore the establishment costs are tremendously on the rise. Naturally, where do they get the money from? The money can be only through one source, which is the fees. The second source, unfortunately, that is not what is presently the colleges or the institutions are banking on. I had gone once to IIT Bombay and they say there is a practice that after completing 25 years, the class then pulls in money and makes a handsome donation to the alma mater.
Yeah, I think they should do that. The lawyers can afford to do it.
I think, that's a wonderful tradition that we can follow. And as lawyers, if we start making that donation, which comes up every year from a different batch, that will actually put in the college with a lot of resources at its command, and that will help giving some relief to the students concerned. But what concern that you have raised is definitely a matter to be flagged, yes.
Thank you so much.
Sir, one more question. Here, sir.
No, sir, I'm so sorry, I missed the first part of your question.
I think if you can appeal 10 top Supreme Court lawyers, give only 10% of the income donation. That will be enough to run the entire legal system, I think.
The entire
Very
legal
well.
framework
Very
of
well,
this
very well. I take the point, and I'll certainly, work in that direction, yes.
Justice Lalit, one more question.
Sure.
So recently, with respect to the elevation of lawyer from Delhi and Madras, there was this talk about the judicial bias. So how judges bring down the judicial bias or prejudice to ensure non-partisanship? Is there any routine or SOPs which you follow?
See, again, your question is directed at the collegium system. I can't answer this question unless you give me 10 minutes.
I think we'll have to have a separate interview with him on that. Thank you so much. We've
Thank you
completely
so much.
run out of time. But
And
I hope we can
I
have-
must say that, this is my first exposure to ThinkEDU. I enjoyed this session perhaps as much as you enjoyed listening to this. Thank you so much.
Thank you.